Afternoon, everyone. Thank you for joining us. Gonna give it a second for folks to come in from the waiting room, but welcome, welcome. Emily, I've got a lot of different open tabs, so it's hard for me to see if we've got everybody in from the waiting room. If Are we good to go?
The number's still climbing a little bit, but we should be good.
Okay, perfect. Well, I know that our presenters today have a lot of great information to cover with us, so I want to make sure I give them plenty of time to get into the topic today. Thank you all for joining us. My name is Karen Murillo. I am a co-chair of the A&E Committee, or Anti-Abuse, Neglect, and Exploitation Committee, along with my wonderful, fantastic co-chair, Ellen Cheek, who's also here in today's call. We are hosting today's Lunch and Learn on the voting rights for facilities. And we are really, or residents of facilities, I should say, and we're really excited to be hosting our two amazing presenters today. As a quick plug, I'll share that the A&E committee, that Anti-Abuse, Neglect, and Exploitation Committee, we are a small but mighty committee of the Elder Law section. We work to identify sources of crime and elder abuse and other forms of abuse, exploitation, neglect against older and vulnerable adults. We look to see what policies are in place, what response systems are in place, and how to address this, whether it be legally, legislatively, or by other means. We review a lot of different topics, including topics related to age discrimination and vulnerable adult protection. So we meet the fourth Tuesday of every month at noon, which would be today for our August meeting. And we would welcome you all to join us for a meeting or to join the committee if you're interested. I'll make sure to, after I'm done introducing our presenters, put our email in the chat so you can reach out if you have any questions or let us know if you're interested in attending. Okay, so without further ado, our amazing presenters today. We have first Laura Lee Minatello, the Senior Public Policy Analyst at Disability Rights Florida, as well as a self-advocate with cerebral palsy. In addition to working with Disability Rights Florida's broader policy agenda, Laura began her time at DRF as the agency's voting access advocate and currently oversees DRF's voting work, helping to protect and the right to private and independent access to the ballot box for Floridians with disabilities. Laura holds a Bachelor of Science in Psychology from the University of Central Florida, Go Knights, and is currently working towards a Master's of Nonprofit Management, also with UCF. Our second presenter today, who actually will be the first one to talk, I believe, is Tony DePalma. He is the Director of Policy and Advocacy for Disability Rights Florida, the state's federally authorized protection and advocacy system benefiting all Floridians with disabilities through the provision of free and confidential legal and advocacy interventions specified across 10 or more federal grants. Before this, he worked as an attorney, policy and budget analyst, and special master for the Florida House of Representatives. And he was an assistant general counsel for the Florida Department of Elder Affairs. Tony is from Florida State University. He attended FSU, receiving a bachelor's and master's degrees in communications and a law degree from FSU College of Law. Very well credentialed panelists today, or presenters today. Before I turn it over to Tony, I'll share that our CLE number, for those of you who are interested in self-reporting this to the bar, it's going to be 9972. It's in the title for the presentation. And for anyone who is attending from out of state seeking credit, please email Emily Young with the Florida Bar. Her information will also be in the chat. She can help you out. All right, without further ado, let me turn it over to our amazing presenters. Tony?
Thanks so much, Karen. Thank you, Ellen. I was looking to see if any participants dropped out after the CLE number was given, and didn't look like they have. So that's fantastic. It means that folks might be here to learn this information and to have a conversation together, which we're very thankful for the opportunity to do. These are issues that we'll be talking about today that, as fate would have it, even though we kind of agreed to this presentation a month ago, have become very news relevant in different regards, including this week through some decisions at the Supreme Court that are coming out around mail-in balloting, et cetera. So, uh, my name is Tony DePalma. I have the very good privilege of being the Director of Advocacy and Policy at Disability Rights Florida in our Tallahassee office. I'm white with a, let's call it, short brown hair and a big white beard, wearing a black shirt. And with me today, my co-presenter, Laura Minutello. I'm going to toss it to Laura for an introduction real quick.
Awesome. Thanks, Tony. I won't take too much time introducing myself. Karen did a great job, but just for a quick visual description of myself, we like to give those in case anybody is visually impaired. I am a woman sitting in a wheelchair with a pink shirt, and pretty messy curly brown hair as well as glasses. And we are going to start the presentation by giving a quick overview of Disability Rights Florida and our PAVA work, our protection and advocacy for voter access work, as well as an overall presentation, the overall presentation. So, for those of you not familiar with Disability Rights Florida, we are part of what is called the protection and advocacy system. There are 57 of us, one in every state and territory, and we are congressionally mandated to provide legal and advocacy services across disabilities for those with disabilities. Our voting work is done under the Help America Vote Act, or HAVA, of 2002, and that grant specifically is administered by the Administration on Intellectual and Developmental Disabilities, which operates under ACL, the Administration on Community Living, under HHS authority. And we'll go into a little bit of what we do under our PAVA grant. First and foremost, it's important to know that we cannot litigate under our PAVA program. That is a specific prohibition under our PAVA funds. So if we're bringing voting litigation at all, it is under different grant funds or pro bono. However, we can do non-litigation work, including administrative complaints, lots of systemic collaboration that can look like a bunch of different things, including working with the supervisors of elections to provide poll worker training, to provide accessibility reviews for polling places and polling place monitoring on election day and during early voting. That can look through like education and training for people with disabilities, or for the or like we're doing here today for you all. It can look like educating policymakers. It can look like under lobbying provisions. It can look like lobbying on voting specific bills. So there's a lot that we do, even with that litigation prohibition. Next slide. So just for a high level overview of today's presentation, we're going to go through the history and evolution of federal legal protections, and then as well as how they overlap and align with state law, the shifting regulatory landscape federally, some practical considerations, so a lot of what that all means practically and what we see on the ground, how to go about getting help for your clients if they have a HAVA complaint or need to vote and their voting rights in facilities are being they're being disenfranchised, and then some additional resources and information.
Cool. And then my stage cue tells me it's my turn now. So we're going to jump right into the federal legal protections. Laura mentioned the shifting federal regulatory landscape. That's a little bit of what I was previewing in terms of things that are happening in the news right now. And as is the case with the whole bunch of what's happening in the news right now, gestures from the administration, court reverberations, and how that all kind of trickles down to the law or how these rights are understood and enforced for residents of facilities, long-term care facilities. I think it makes the most sense to kind of pull back the aperture and look first at how we got here, what the federal laws have sort of how they evolved and how we have arrived at these protections. So with your indulgence, I would just go through a couple slides here. So as with most things related to voting rights, there were aspects of this conversation that were kicked off in the Voting Rights Act of 1965. Although the act itself did not specifically extend protections to voters with disabilities, but importantly, it did ban literacy tests and related educational requirements. It took an entire 17 years for the Voting Rights Act to begin to be opened up to cobble together protections and instructions for how these laws and how these rights distinctly apply to voters with disabilities. So one thing you'll hear lots about, and I think it's an important thing to kind of begin our conversation around today, is Section 208. Section 208 is a part of the Voting Rights Act. It was actually passed in the Voting Rights Act amendments of 1982. There was a couple series of amendments. Section 208 says clearly, any voter who requires assistance to vote by reason of blindness, disability, or inability to read or write may be given assistance by a person of the voter's choice, other than the voter's employer or agent or that employer or officer or agent of the voters union. And again, as this went through, as it was passed by Congress, as these amendments were put onto the Voting Rights Act, an accompanying U.S. Senate report noted, it is only natural that many such voters may feel apprehensive about casting a ballot in the presence of or may be misled by someone other than a person of their own choice, and to do otherwise would deny these voters the same opportunity to vote enjoyed by all citizens. So that's our first moment in this presentation to consider the concept of undue coercion or misleading voters. And we're not going to parse that at the moment, but we are going to return to consider other ways that that concept is sort of growing within the conversation more broadly. So around this same time, back in the early 80s, disability rights and aging justice organizations highlighted widespread documented instances of polling places situated, for instance, in basements without elevators, up steep flights of stairs, or featuring narrow entryways that barred access to voters with mobility or sensory impairments. So as a result, the Voting Accessibility for the Elderly and Handicapped, their words, not mine, Act of 1984 was passed with overwhelming bipartisan support and provides for accessible polling places in federal elections for elderly voters and voters with disabilities. This is important for a couple of reasons. In a minute, we'll explain how this law has evolved into other laws and other protections. But in terms of what the Voting Accessibility for the Elderly and Handicapped Act did, states are required to provide alternative voting methods, such as absentee or mail-in balloting, when polling locations could not be made structurally accessible. And states must also provide specific aids to voters with visual or hearing impairments, such as large print instructions and alternative communication tools needed to review information of ballot instructions. This was the genesis, the origin of a lot of what we understand as these protections and as they've evolved into things that we'll in a moment discuss. But I'd like to just point out that they specifically provides that states are required to provide alternative voting methods, such as absentee or mail-in balloting, when polling locations could not be made structurally accessible. So around this time, very important to the current discussion, the Nursing Home Reform Act of 1987 was passed. This act does a whole bunch of things that were game changers for how rights are understood for residents of congregate facilities, nursing homes, long-term care facilities. So although the act primarily addresses medical care and resident well-being, it also established a resident's Bill of Rights. So this actually is information I'd like you to hold in mind as we get to talk about the shifting regulatory landscape. You'll see that some of these requirements have made their way into this regulatory landscape, which in my mind is reassuring. It connotes that there's a direct through line between all this foundational bedrock laws from long ago, the 70s, the 80s, the 90s, the 2010s. Even though current regulatory gestures or current things that are becoming uncertain or being characterized as like unsafe or incorrect, there's still a through line to these laws. So the Nursing Home Reform Act, all residents retain all of their rights as a citizen or resident of the United States. Period, point blank. That's a big statement that I'd like for folks to have in mind as we're having this discussion today. Facilities also must ensure that residents can exercise those rights without, and here's the big thing you'll see in a couple later on in the presentation, without interference, coercion, discrimination, or reprisal. You'll notice, however, that coercion is placed on par with other things that facilities can't do, like discriminate or act punitively against folks exercising their rights or interfering with those rights. Facilities also must actively support residents in the exercise of their rights. And very importantly for our discussion, facilities can't gatekeep, for lack of a better word, the exercising of these rights by unilaterally deciding that a resident lacks legal capacity or competency to vote. Again, we'll say it a couple times during the presentation today. The only way you lose the right to vote in Florida is if you have a felony conviction, a certain felony conviction without being restored, having your rights restored through all the fines and fees and processes we've spent much of the last decade talking about in the state, or if you have a judge rule that you are incapacitated with in regards to the right to vote and you have that right removed from you. Those are the only two ways someone loses the right to vote in the state of Florida. Every single Floridian. So keep that in mind as we're continuing through this trek along important federal legal protections, including one that I'm sure folks are well aware of. So under the Americans with Disabilities Act of 1990, it's illegal for state or local governments to discriminate against people with disabilities in the administration of any part of the voting process. So Title II of the ADA requires full and equal voting opportunities for disabled individuals, including during early, mail-in, and election day voting administration. Governments must ensure that physical structures used for voting do not block or prevent voters with disabilities from casting a ballot. That's a separate discussion we can have anytime y'all would like. Election officials must make reasonable modifications to policies and procedures to accommodate the individualized needs of disabled voters, and states must provide auxiliary aids and services to ensure, and this is an important concept in disability law, effective communication. So the ADA is certainly part of this. Although the very last relevant part of this is one that's very Florida specific. Folks on the call might have been alive in the year 2000. I was in college, about to go to law school in a couple of years, and I remember the CNN trucks outside of the law school, outside of the Civic Center in Tallahassee. So, following the 2000 presidential elections, dreadful music commences, and the related fallout, a separate post-election investigation by the United States Commission on Civil Rights, an entity that's very concerned or has historically been very concerned with voting rights, documented massive failures under the existing framework of the Voting Rights Act and the ADA for voters with disabilities. These included things like inaccessible polling locations, paper balloting problems, and inadequately trained poll workers. None of those things have really changed in the last 26 years, I would argue. However, one thing that did change is Congress acted. So they passed the Help America Vote Act of 2002. Earlier, Laura mentioned that our own voting authority, the authority to do this voting work, is a subset of HAVA. So our PAVA grant is a subset of HAVA. But in terms of what HAVA provides, it ensures that every polling location used for federal elections must have at least one accessible voting machine. Voting systems, including ballot marking devices, audio tactile interfaces, et cetera, must allow voters with disabilities to cast ballots. And here's the very important language: privately and independently. And voters are permitted to cast, this is also important language, a provisional ballot if their registration is questioned at the poll site. So hold all of those concepts in mind while I turn it back to my colleague, Laura.
Awesome. Thanks, Tony. We are going to go over now some of the relevant state law and how that aligns with federal law. And I will also try to interject some of what we see practically, regardless of, and including how state law is written. So, next slide, Tony. Tony just talked a bit about the accessible voting systems. Our state law does line up with HAVA, and requires at least one uh, accessible voting machine in every polling place during a federal election. There are two systems in use in Florida, the Express Vote and the ImageCast. Practically, there are some differences, but generally they work the same. They can do things like read out the ballot to individuals. There are magnification capabilities. They can be used with foot paddles if somebody lacks arms or dexterity. It's a touchscreen device. But I think, it's important to kind of practically mention that although these systems are present and sometimes present in larger numbers, Palm Beach, for example, uses these for pretty much all of their early voting. So everybody will vote on one of these machines. A lot of times poll workers don't often know how to use them. That is something we are working to help better train on. And we will see things like them placed not in private settings. So they'll be maybe facing the door of a polling location or somewhere where somebody can walk by and see. That is against the spirit of HAVA. That doesn't provide for privacy and independence. As far as polling location accessibility, again, state law aligns with federal law in that, as Tony mentioned, that if a polling place cannot be made accessible, another way of voting, specifically vote by mail or absentee voting, has to be made accessible. We do see, DRF do poll site monitoring both on during early voting and election day. We actually partner with Common Cause of Florida and the Lawyers Committee under Civil Rights to send out legal monitors as well as our own staff. So we get to a fair amount of polling places every election cycle, and we still see a number of problems. Part of that is due to the fact that under normal considerations, the places of worship like churches or synagogues are not subject to the ADA. However, they are subject to it when they are acting as a polling location. So we work with the SOEs to make sure that temporary remediation, whether that is utilizing a cone to create disabled parking spaces, whether it's having ramps and appropriate signage, we will encourage the SOEs to do their due diligence in making sure that those are accessible. But we see a lot of places where accessibility physically is still a problem, making those other options even all the more important. Personal voting assistance, again, aligns with federal law. This is another area, though, where we see people sometimes question the amount of or who folks can have assist them. In person, a lot of times we'll get questions from poll workers just wanting to make sure that somebody bringing in an assistant is actually they are assisting them and there's no coercion. That's perfectly in line. Anybody assisting in person has to fill out a declaration that just basically says that they are assisting a person with a disability, that this person is choosing to have this assistance, and that falls within applicable federal law and state law, and not being the employer or a union representative. I'll give a personal example of this one that surprises a lot of folks, though. I have a family member who is also disabled, and she has had her minor son, assist her in voting. So there is no age limit This is also something that we worry about, though. Tony mentioned Section 208. And so when we're talking about state law specifically, uh, uh, vote by mail or um, absentee balloting, there are limits, which we will go over in the next slide, to what Florida allows a person to return a person with a disabilities ballot, or just any person, which we have concerns about in terms of it limiting a person's assistance of their choice. And the last one that I will hit on this particular slide is accessible vote by mail. This is something that, as the slide says, is a work in progress. This was actually in statute for 20 or 30 years, but was not challenged until 2020. The Florida Council of the Blind, during COVID, a lot of folks with disabilities and other folks as well obviously had trouble getting out to polling places. And so the Florida Council of the Blind brought litigation forth based on this provision in statute that allowed eligible voters with print or visual disabilities to legally request electronic remote ballot delivery systems, and that is just delivery. So what happened, and they won. And so now we have a system in which qualifying individuals with disabilities can request from their SOE a link. It's usually sent by a link to their vote by mail ballot, and they can use that link to fill out their ballot on their personal computers with their screen readers or other technology. However, this is not completely accessible in that it still law still requires the ballot to be printed out and signed, which specific to those with visual disabilities is often a problem in that, just even printing or knowing where, even if they can get it printed, knowing where to sign is is uh is an issue. So 12 states do allow the fully accessible remote balloting, including return. That is something that is a work in progress, as I said, though. Specific to supervised facility voting, Florida statute has a specific framework that allows and the SOE essentially to come into any designated nursing home or assisted living facility, those two things specifically, to administer an election. But within those considerations, the individuals, first of all, it doesn't say so on the slide, but state law requires that 5 individuals, so let's say we have any, nursing home ALF in the state, 5 individuals most likely have to request the supervised facility voting. An SOE may visit a nursing home or an ALF in the absence of a request from a facility, but honestly, what they do or don't do varies beyond county. So the most surefire way to receive assistance is to have it requested through 5 residents. And the problem there, though, is that once staff request the SOE to administer an election, there is no requirement then that either the staff inform the SOE or that the SOE itself has to, upon receiving the request, administer the election. So there's really no follow-up there. But if it is working correctly, what happens is that the staff from the SOE office visit the nursing facility or the ALF, and they bring a voter's vote by mail ballot. And they're there to assist as appropriate with and take all the ballots back to the office. Um, so at least two SOE staff members will be there, and voters can ask for assistance for someone else, for, whether that be someone from the nursing home or even an assistant of their choice. Say their family member is there, they can ask for another assistant that's not the SOE staff, or they can decide to fill out their vote by mail request later. One other thing of note here, though, is that, well, two other things. This law does not cover a lot of situations like smaller group homes or facilities that we feel could benefit from this. And the other being that this is all paper balloting. So while they are there to assist, they don't bring out the accessible voting machines. So there's still some of that loss of privacy and independence.
Cool. Back to me. Thanks, Laura. And the points Laura was making there are really important to consider. Florida does have an apparatus for folks in facilities. And again, Laura made the point. It's assisted living facilities and nursing facilities to request supervised facility voting. There's a process to request it. If you really pull back a little bit, though, the process seems to be contingent on an administrator making the request and or a supervisor extending staff to complete a request like that, which absolutely doesn't place the power for requesting in the resident's hands like it should be. And then again, in terms of it only being ALFs or nursing facilities, in past litigation with the state has argued that the definitions for ALF in Chapter 429 and nursing facilities in Chapter 400 are broad enough to include things like group homes or short-term residential treatment facilities, some of the other congregate settings, intermediate care facilities, some of the disability-specific congregate settings. We'd be hoping that a similar ability to do supervised facility voting would be extended to. Sometimes it seems like some supervisors' offices are willing to do that, but we're unsure. We're unsure. We can't find any publicly available information where these processes are being marketed to those other types of congregate facilities. But for folks on the training here, it certainly applies to assisted living facilities and nursing facilities. And it would be one of the things we would ask folks to consider as some of these other things begin happening, including the shifting federal regulatory landscape of which we speak. So very recently, the Centers for Medicare and Medicaid Services, CMS, this is Dr. Oz's CMS, issued a memo rescinding previous guidance from CMS pertaining to the rights of nursing home residents seeking to exercise their right to vote. So previously, so what we're talking about here is how the guidance used to read. The guidance had affirmed the right of nursing home residents to exercise their right to vote. That kind of sounds like Vieja a little bit. Provided that facilities must ensure that residents can exercise this right without interference, coercion, discrimination, or reprisal from the facility. This sounds like Vieja. Clarified that residents should be supported by facilities in the exercise of their rights, required facilities to, quote, coordinate and engage with programs like supervised facility voting, which, to my point I was just making, that this is all triggered by administrators or supervisors' offices rather than residents, is very important. It had encouraged states, localities, and nursing home administrators to collaborate to ensure a resident's right to vote is not impeded. And very importantly, it had provided that facilities must ensure that residents have the right to receive and send ballots via the U.S. Postal Service or other authorized mechanisms that are allowed, providing reasonable access to postage and writing implements, and the right to promptly send and receive unopened mail and voting materials that are delivered. And promptly had previously meant within 24 hours. So pretty serious stuff. This guidance, the new guidance that CMS issued, is titled Protecting the Voting Rights and Autonomy of Vulnerable Residents in Long-Term Care Facilities. So to connect an earlier thought where all of a sudden it's coercion and the resident's ability to vote or, that is suddenly in balance here. So this memo largely hinges on an assertion by CMS that it has, quote, become aware of several allegations of instances in which resident rights were unlawfully violated, including a Wisconsin Sheriff's Office investigation of an alleged incident where, quote, 8 men and women whose mental capacities had diminished due to age or disease, their words, not mine, sent mail-in ballots from a care center in Wisconsin. And although this memo reiterates that nursing homes' responsibility, although this memo correctly reiterates nursing homes' responsibility to preserve residents' right to vote and to promote participation in the democratic process, it also notes that this activity should not violate federal or state voting laws. And CMS is reminding facilities and their staff that they cannot engage in inappropriate coercion or other violations of residents' rights. So for folks that are keeping score at home, this would seem to create a really vexing sort of situation here where we've kind of created a system where folks who are in need of receiving assistance from facility staff or other folks, as they probably have for many, many elections, now suddenly we have guidance coming out from CMS that applies to all licensed Medicare and Medicaid facilities in the state, kind of maybe trying to scare those administrators and the facility staff into doing what I believe state law contemplates them doing or had contemplated them doing, and in a way that might leave folks in facilities without a real understanding of how they're supposed to vote. A lot of folks in facilities, either by preference or by circumstances, are not able to leave their facilities. And if mail balloting is thrown into disarray or doubt, and some of these other processes or some of the other goodwill that folks had relied upon to be able to cast a ballot is thrown into doubt, that is potentially catastrophic. So we're going to continue talking about this regulatory guidance real quick. So this memo nonetheless affirms and reiterates the following. Here's the good stuff. So residents have the right to exercise their right to vote while at a facility. That's vieja. Facilities must ensure that residents can exercise those rights without interference, coercion, discrimination, or reprisal from the facility. That's vieja. Residents have the right to be free of interference, coercion, discrimination, and reprisal from the facility in exercising his or her right, and to be supported by the facility in exercising the right to vote. That's all the federal law. However, this memo again reminds facilities of, quote, their obligation to promote participation in the democratic process for residents while complying with all applicable federal and state laws and regulations to avoid instances of coercion or otherwise violating residents' rights or voter protection laws. Y'all, there's a lot to be said about the correct way for facility administrators and staff to engage with their residents to promote participation in the democratic process that is not coercive and is not born out of undue influence or anything like that, but instead hinges the entire reason we're extending that right to voters as an empowerment act. This isn't it. So this is very confusing and problematic guidance that's coming out of CMS. And I would argue that at the moment, there's many senators and congresspeople who are writing, complaining about this guidance and trying to seek further remedy or further instruction. Again, this doesn't change the law. That's something at Disability Rights Florida we talk about a lot, about all the things that don't change the law. Courts change the law, and the laws are passed by Congress. That's an important dynamic to keep mindful of here. So although the law isn't changed, this does impact the ability of CMS to help with regulatory enforcement or to be responsive to facilities or facility residents who are in touch and contacting saying that they've had their rights removed or taken away from them. Final slide on this. So aside from the 2 alleged background incidents, which I would like to say didn't result in any ballots being cast incorrectly, so hold on that thought and keep that in mind too. The only reference to mail balloting comes in a reference clarifying that, quote, nursing homes may not engage in any activity that violates federal or state voting laws, including, quote, actions like registering residents as voters without their knowledge or consent or completing a mail-in ballot on a resident's behalf without authorization. This memo notes that residents requiring assistance to vote should have the option of receiving assistance from the person of their choosing, and further encourages facilities to, quote, coordinate with state election officials to encourage the use of bipartisan election workers where authorized by state law, as it is in Florida, to facilitate voting in long-term care facilities without reliance on facility staff, thereby reducing the risk of undue influence wherever possible. So although there's a lot of doom and gloom and uncertainty in this memo, the memo does correctly underline what is still the law in terms of how residents and facilities have these rights and are able to exercise these rights. And it seems to be making a pitch to states that have an apparatus like supervised facility voting to make sure that that's a way that states and facility administrators and supervisor staff can ensure that there isn't undue influence or coercion. So I'm going to keep moving the slide in the interest of time here. Back to you, Laura.
Thanks, Tony. We're gonna just go quickly over some practical considerations. If anybody has any other further questions, we're happy to answer them, but I'll try to go quick just in time. We talked a little bit before about ballot possession and alternatively termed as ballot harvesting, and the fact that as of 2021, the Florida legislature limits the ability to collect ballots. So in law, you can possess two ballots or return two ballots other than your immediate family member. Also, just to note, that includes a person's spouse, parent, child, grandparent, grandchild, or sibling, or the person or the person's spouse. I think that's twice there, but and that in 2021 those penalties were increased. It was originally a first degree misdemeanor. It's now a third degree felony. So these are serious penalties, and in and around that there is the exception for supervised facility voting. So a election administrator coming in and collecting those ballots is not considered ballot harvesting, but it does somewhat limit otherwise the assistance of a person's choice. Just very quickly, there's voter identification and signature concerns. Some of this is going to change as of November. Some of the voter identification things listed here, such as retirement center identification or public assistance identification, is no longer going to be able to be used when you're voting. But as of at least the primaries, this was correct. So that is going to change in November, but generally, even voters that don't have proper ID can still vote a provisional ballot as long as the voter is eligible and votes in their proper precinct. The provisional ballot will count as long as the signature on the provisional ballot matches the signature in the registration record. And all I'll say there is that is a concern for many elderly individuals and people with disabilities, in that a lot of times when we sign, our signature does not match, just because it changes so often, and there is a process to cure that. It is not necessarily the most accessible process, but there is a process as of 2018 that allows for cure. So somebody, though, if they don't have the proper identification or signature, can still vote. I'll turn it over to Tony.
Thanks, Laura. And so we're going to kind of pivot into getting help, additional resources, and hopefully making the pitch to everyone that's tuned in today of how they can help to enforce and make sure that residents of these facilities have the full bevy, the full gist of their voting rights. So let's start with this memo. So in terms of getting help from this memo, I would note that the memo provides that nursing home residents or their representatives who believe their rights under these regulations have been violated can file a complaint with their state survey agency. Unfortunately, if you click the link in the memo, it takes you to an inactive website. So that's frustrating. I would commend for folks to research what Florida's survey agency might allow for in terms of complaint process. However, this memo also notes that allegations of voter coercion or intimidation can also be referred to the Department of Justice for filing voter complaints with the Civil Rights Division and through email. So that is one apparatus of getting help. And in fact, that seems to be the prescribed federal means of requesting assistance. We talked earlier about HAVA. A very important thing that HAVA did create was a complaint process unto itself. So Title IV of the Help America Vote Act mandates that each state must maintain a uniform administrative process, allowing any individual to file a complaint if they believe a violation of HAVA's Title III has occurred, is occurring, or is about to occur. Now, a complaint only qualifies under HAVA's Title III if it directly involves specific federal voting requirements, including such things as voting system standards, provisional voting, voter information requirements, statewide voter registration database matters, and importantly, accessibility. I would note that in broad strokes, Title III of HAVA and Title IV's complaint process tends to be matters related to physical accessibility, like voting in person, and how that all works, like whether a provisional ballot was denied in person, etc. And that may or may not color the availability of relief under HAVA Title IV complaint or Title IV complaint. So in my illustration of what I'm trying to say here is that Florida's own HAVA complaint form, which I have linked here, and I note hasn't been updated in more than 2 decades since the dang thing was passed, must be signed and notarized, directs complainants to state, quote, the specific acts committed by the person or entity named in the complaint, and contains a section where complainants can provide a detailed statement of facts. So, although the complaint form itself doesn't really include a prescribed process for what happens when a complaint is filed, the statutes do, and they provide that when a legally sufficient complaint is filed with the state, I put that in quotes, a hearing officer is thereafter designated who shall, one, provide the subject of the complaint with a copy, and that subject has 10 days to file a response. The complaint and the response becomes the official hearing record, although the hearing officer may order additional oral or written testimony or documentation. A hearing officer's determination results in dismissal or issuance of an order directing an appropriate remedy, and states must make final determination of complaints within 90 days after receipt, unless the complainant consents to a longer period of time. And if the state fails to meet the deadline, the complaint is forwarded to mediation. All of this process, all of this due process is itself very confusing, and I am not able to endorse how well it works or how available it is as a remedy. Although I am absolutely of the opinion that folks who are in a position where have a complaint might be in bounds to file, I would love to be in touch together as they pursue those. Or I would love for Disability Rights Florida. Again, we are not able to litigate under our voting access grant, but we certainly can carry administrative complaints accordingly. So although this isn't something I can endorse, I certainly would love to be in touch with folks who are seeking remedy or relief under HAVA's complaint process. Finally, the last slide of getting help, it's us. So disability, man, don't let our executive director hear me massacre our name like that. Disability Rights Florida. We maintain a voting hotline year round. Laura answers it when she's able, including during all periods of voting in the state. There's the 800 number. It's important to note that there are other election protection hotlines. Laura mentioned earlier that we are in partnership with Common Cause Florida, as well as the Lawyers Committee for Civil Rights under law. A lot of that puts us in contact through the Boiler Room and other aspects of the Election Protection Coalition when there are disability-related calls. So we would encourage folks to call through the Election Protection Hotline as needed, and you'll see I listed some alternate language lines that the Protection Hotline maintains as well. And also importantly, there are many other organizations out there available to assist. I wanted to note specifically that NAD, the National Association of the Deaf, has an American Sign Language voter assistance hotline. But if folks are wondering what other reservoirs or places for help exist out there in the wilderness, we would surely be interested in helping connect those dots for folks. I think I toss it to Laura for a wrap up.
Yeah, just really quickly wanted to mention some other resources and additional places to get additional information. Our resources, a lot of them can be found at our website, or if you have other questions, I'll send them to you. But some to highlight are our voting rights brochure and some of our plain language explainers. There's also the National Consumer Voice for Quality and Long-Term Care. that has a voting rights for residents in long-term care facilities explainer. And then lastly, one of the best resources that I know of is the United States Election Assistance Commission. It's independent and bipartisan. And its mission is to help election officials improve administration of elections and help Americans participate in the voting process. They have some great resources on voting accessibility. And I think now we could take a few questions if there's some time.
Well, Lee and Tony, thank you guys so much for presenting today. This has been very informative and interesting. You do have a question in the chat. Are there any statistics available on the number of adults registered to vote who live in ALFs and SNFs as compared to the number who actually voted in the last election?
Laura, are you aware of any data collection like that that's available?
I am not. I can reach out to some folks. They're the best kind of data that we have available usually comes from Rutgers University. Doug Cruz and Lisa Sure, they do a lot on election accessibility, but that specific area is not one where um they have research to my knowledge, but I'm happy to follow up with them and see if they know either have that I don't know of or know of anybody that has that we are not aware of.
Well, note, just as piggyback to what Laura's saying, Laura mentioned some of the very vital reporting that's come out across the last 4 or 5 election cycles, so last couple decades from Rutgers University regarding voting with a disability and a concept that is always touted and central in that reporting is the turnout gap for voters with disabilities compared to their non-disabled peers. And it seems to be a percentage that we're making significant inroads into correcting. But again, it's sort of a perturbing just facet of this work that historically, cycle after cycle after cycle, the amount of folks with disabilities voting is somewhat and often substantially less than their non-disabled peers. And so I imagine that that same concept might be true in facilities, although we live in Florida. Florida has done two very important things historically, and I don't know that they were ever done in service to disability voting rights. Florida has created mail-in balloting as a centerpiece of its election administration. That is a concept that's supposed to help correct the ability or any gap that emerges from folks who don't travel to the polls, aren't able to travel to the polls, or would just like to have a simple way to vote through the mail. Again, that's always what's characterized as a huge election insecurity feature is the mail balloting these days. But always remember that Florida was one of the first states to do to do mail-in balloting the way it has. It's technically a no excuse mail-in balloting. You don't have to explain why you're choosing to participate through mail. It could just be how you feel, but it's always been a centerpiece of elections. And something else we talked about today was supervised facility voting. So it's important to know that if that's working right, if those two things are working right, maybe it shouldn't be a turnout gap for residents of facilities. Maybe in a state like Florida with lots of folks who are in congregate placements, lots of seniors especially, maybe it's a turnout surplus. Maybe, that number clicks the other way. So if our election administration systems are working for us rather than against us, these are things that should naturally be corrected and don't therefore require immense or Herculean advocacy to correct. So
I will say, in relation to the turnout gap in general, that is currently around 5%. But as Tony mentioned, that is a number we've actually seen progress in, especially in the last few years, from about 7 or 8% or more. I think at one point it was 12. So it is going down. So as Tony said, though we don't have specific to facilities, some of that I'm sure could be extrapolated.
One of the things that it looks like those are the questions that we've had, and I'll also share that for the folks on our call, we have reshared the links that were mentioned in today's presentation. And we'll make sure that you get copies of these in some form because I'm not sure they were enabled in the PDF that was sent out. But one of the things that you guys talked about with the 2021 changes to the law, it struck me that the immediate family member obligations have far-reaching implications beyond just talking about people living within facilities. I mean, it can impact caregivers of choice, right? So this is something that could impact a lot of different people in a lot of different settings. Do you know if this issue was challenged previously, or if there's been any discussion about doing that?
There's been
Tony, I'll let
lots of
you take that
discussion.
one.
Yeah, please. Yeah, there's been lots of discussion around that. Karen, you've zeroed in on like a really perturbing aspect of what happened in Senate Bill 90 from that era. And it was a matter that Disability Rights Florida litigated, several other voting partners litigated. But the only thing I want to mention is in terms of the ballot possession law and the criminal penalties that attach and how family members is defined, there was amendments offered to create a caregiver exception. And I, Tony DePalma, the person who watches Florida Channel 20 hours a day, sometimes during session, am here to tell you that those were flatly voted down. With the boo of chorus, with the thumbs down, the Florida legislature and many Florida legislators did not want to have a caregiver exception. Other states that have created restrictive ballot possession laws in recent times have created caregiver exceptions. And states that haven't have had those challenged. But in all the litigation in Florida, it has never been squarely challenged that Florida's process for ballot possession and criminal penalties might be a violation of Section 208 of the Voting Rights Act. It's an open question in my mind. It's an open question in many people's minds, I think. But Karen, you're eagle-eyed and you zeroed right in on it.
Thanks, Tony. I really appreciate you guys. The presentation today has been incredibly informative. I so appreciate you giving us the next steps in terms of how we can be advocates. I will keep an eye out and see if there are any other last minute questions that pop up, but otherwise, I will just thank you both for taking the time, sharing your wealth of knowledge and experience on this topic and issue, and really informing us on something that we don't have a lot of. Well, I'll speak for myself that I don't have a lot of interaction with on a daily basis. So this was incredibly helpful. I'll also share for our attendees today, the CLE code again is 9972, which you will self-report to the Florida Bar if you have any questions, or if you are an out-of-state professional seeking credit, contact Emily Young. Her contact information is in the chat. Oh, we may have gotten one more. Oh, we got not a question, but this was wonderful. And I will second that. You're getting some praise in the Q&A in the chat. So well done. Thank you. And I hope everyone has a great rest of your day. Thank you for joining us. And please tune in for A&E committee meetings like this in the future. All right. Thank you all.
Thanks, y'all.
Thank you.